Hey, everybody. Welcome to the breakdown on Substack and, of course, All Rise News on Substack as well. My name is Allison Gill. I'm here today with Adam Klasfeld because we just got a 1-2 punch knockout round. More knockout for Jim Comey than for Letitia James, but both of their cases have been dismissed because Lindsay Halligan was unlawfully appointed under 546 and under the Appointments Clause. And further addressed in these dismissals is Pamela Jo's attempt to get into a time machine, fire up the DeLorean, turn on the flux capacitor, and go back in time to appoint Lindsay Halligan properly under 3 other statutes. And also, it's important to note that these indictments have been dismissed without prejudice, despite Jim Comey and Letitia James asking for them to be dismissed with prejudice. And we'll discuss that as well. So please welcome Adam Klasfeld from All Rise News. Hi, Adam. How are you?
Doing well, Allison. What a way to start Thanksgiving week.
Yeah, that's what I was wondering, when this was going to come down. And also how it's going to impact some of the other motions to dismiss, particularly certain ones with prejudice that are being heard by a different judge, right? So talk first about why Judge Curry from South Carolina was the one
Correct.
deciding these particular cases as opposed to any judge from the Eastern District of Virginia.
So the reason Judge Curry has this particular motion in front of her, has decided on the disqualification of Lindsay Halligan, is they needed someone outside of the Eastern District of Virginia. And this has been the case throughout. Just to take a big picture here, this is the 4th Trump appointed U.S. attorney who has been ruled disqualified, unlawfully appointed, illegitimately serving in her position. She follows in the footsteps of Alina Habba in the District of New Jersey, Sigal Chattah in the District of Nevada, and Bill Asali in the Central District of California. This is the 4th Trump-appointed U.S. attorney in a row that when Trump chooses a loyalist to do his bidding outside the way that the Constitution prescribes and the U.S. Congress had prescribed in the Federal Vacancies Reform Act and other statutes that are applicable here, that this has to go to a judge outside the district because it is potentially a conflict of interest. And what a federal judge has found today, and has gone farther than any of those other federal judges who have disqualified those other Trump-appointed purported U.S. attorneys, she has found that because she was the only person, Lindsay Halligan, in the grand jury room, that the cases must be dismissed. You had mentioned a little earlier that they are going to be dismissed without prejudice. We'll see, which would technically give the government room to try again. But the plot thickens. Judge Curry says in the James Comey indictment, she tackles an argument that prosecutors brought forward that the statute of limitations has not told because the indictment the government had argued that the statute of limitations clock was paused, that it hasn't lapsed because the indictment told it. And she writes in a footnote that a invalid indictment would not do that. So there will be more litigation on this issue. I'm not going to say that this definitively answers that question, but let's just even imagine a world where the statute of limitations has not expired for James Comey and that he isn't fully free and clear. Let's just imagine that world for a second. This ruling says that the case, if it were to be pursued, has to go through a valid U.S. attorney, one with the advice and consent of the Senate, or one who could pass muster from the judges of the Eastern District of Virginia. Now, we know that there was no willing prosecutor in that district who was willing to take up the cases either against Letitia James or James Comey. So yes, this is a dismissal without prejudice, but we know from this ruling that the way to do it lawfully uh, to appoint a U.S. attorney lawfully might not be someone with. They would need to find someone both with the qualifications to get into that position and someone who's willing to take up these cases. And we found that these are mutually exclusive positions in the past.
Yeah, and the judge addresses the idea of dismissing without prejudice uh, because of another aspect as well. The government had asserted that any dismissal should be without prejudice because for Mr. Comey, it comes nowhere close to showing flagrant misbehavior or substantial prejudice or the unavailability of a lesser sanction as required in a case called Bundy. And there are other motions to do that, but this judge has said those motions are not before me. My only thing that I'm ruling on here is whether she was appointed properly under the Appointments Clause in 546. But
Right.
she goes on to say, and this is an interesting thing that I learned today. She says, I believe the Supreme Court's Appointment Clause jurisprudence provides the answer to the with or without prejudice question. In cases both Ryder and Lucia, the court essentially unwound the actions taken by the unconstitutionally appointed officer and restored the affected party, in this case, Jim Comey and Letitia James, uh, restored the affected party to the position the party occupied before being subjected to the invalid acts.
Right.
So you can't do it with prejudice to send a message. I think what Comey was arguing here, she says, Comey urges me to exercise my supervisory powers and dismiss with prejudice. But that, because to vindicate interests protected by the Appointments Clause and to deter the government from using unlawful appointments to effectuate retaliation against
Right.
perceived political enemies. But that goes against the current Supreme Court precedent in a couple of cases, that you just unwind it to where Jim Comey was before the indictment happened, right? Before Lindsay Halligan indicted him. And something else that she brings up that I thought was kind of I noticed that most of the quotes from the Supreme Court she grabbed come from Clarence Thomas.
Mm.
And I also noted that one of the big points that she brought up, she quotes directly from United States v. Trump when Judge Eileen Cannon dismissed the case against Donald Trump in the classified documents situation because Jack Smith was unlawfully, quote, unlawfully appointed. And she doesn't go into whether or not that's a bunch of BS that, that Jack Smith was appointed unlawfully or not, but that the remedy is to dismiss if you think that that person was unlawfully appointed. She quotes Trump saying, I conclude all actions following Halligan's defective appointment, including securing and signing Comey's indictment, constitute unlawful exercises of executive power and must be set aside. Quote, there is simply no alternative course to cure the unconstitutional problem. And that is a quote directly from the Trump case and the Trump dismissal. So not so much whether or not Jack Smith was lawfully appointed, because he was, more along the lines of, well, regardless of whether you think somebody was lawfully appointed or not, if you find that they're unlawfully appointed, the only remedy is to dismiss the case. And so she quoted the Trump case to do that.
And we can see that coming just weeks ago when she heard arguments on this position. As you know, I was down in federal court in Alexandria, Virginia for those arguments, and she put Trump's Department of Justice on the spot when she asked them point blank, was United States v. Trump wrongly decided? And that was a question. She was obviously referring to the appointment clause challenge against Jack Smith that ultimately dismissed the classified documents case. She asked whether Judge Cannon had it wrong. At first, the Trump prosecutor tried to dance around the question, saying, well, it's the Southern District of Florida. It's certainly not controlling. But eventually he had to try to disavow that ruling. So this is certainly an example of hoisted by your own petard. As it turns out that this defense strategy in Trump's criminal case, one of his most potent criminal cases, has turned out to potentially doom one of the cases against in his retribution tour. So that's absolutely a great citation that you pointed out, Allison. I'll point out to another one. You had mentioned the DeLorean time machine, where Attorney General Pam Bondi had tried to retroactively ratify the actions of Lindsay Halligan. And I thought there was a very salient line from Judge Curry's ruling where she rejects that proposition. She said that the ramifications of a conclusion that credited Attorney General Bondi's actions are extraordinary. It would mean that the government could send any private citizen off the street, attorney or not, into the grand jury room to secure an indictment so long as the attorney general gives her approval after the fact. That cannot be the law. And it reminds me of the oral arguments on this just a couple of weeks ago, where it was, I forget which of the attorneys, it might have been an attorney for
It
James, or
was
it might have,
it was Abby Lowell
it
who
was
said
Abby Lowell.
Elon
Yes, you have,
Musk or Steve Bannon could go into the room. I knew exactly where you were going with that because that is
yes.
exactly what I thought when she said this cannot be the law.
Right. Because what it had she found the contrary, what would stop them from sending any other loyalist, as she says, attorney or not? Now, in this case, Lindsay Halligan is an attorney. She represents insurance companies in litigation, but it's her first rodeo inside any sort of Department of Justice, federal prosecutor, or any prosecutorial position. And she's saying that this cannot be the law. She cannot ratify that. It's very strong language there, and it definitely harkens back to that part of oral arguments where Abby Lowell rightly said, if this is proper, if this is legally acceptable, then you can have Elon Musk or Steve Bannon in the grand jury room going after Trump's enemies.
Yeah, and not to mention the fact that it would completely moot the appointments clause of the Constitution. It would completely moot multiple statutes that have been passed by Congress, including 546, 515, 509,
Mhm.
all of these laws that govern the appointment of a special prosecutor or U.S. attorney. There would be no need for advice and consent on confirming a U.S. attorney appointed by a president. It would unravel tons of statutes and law going back to and including the Constitution. She's like, that's the dumbest thing I've ever heard. I mean, I'm
Mhm.
paraphrasing. Uh,
Well, I to just put this into perspective, we say things like the Appointments Clause, we say things like the Federal Vacancies Reform Act, even though this one is under a different statute that governs the appointment of two consecutive interim attorneys, and it's worth pointing out what these statutory and constitutional protections are for, and it's for cases just like this, that if someone is going to be appointed to a position of power where they're the top prosecutor of a district with the potential to take away your liberty, that individual must have the advice and consent of the Senate. This is what our Constitution mandates. So there's democratic, small d, democratic accountability. Because after this ruling, there's going to be a lot of commentary about oh, this is a Democratic appointee. They're going to go after the judge. And let's talk about what this is all about. This is about the Appointments Clause. There's a reason why judges across the political spectrum have defended this principle in disqualifying now four, count them, and there are more potentially coming with John Sarcone in the Northern District of New York. But that's the principle. Is there small d democratic accountability over top federal prosecutors of districts who have the potential to take away your liberty? And all of these federal judges across the political spectrum are answering yes. She is going a step farther, saying because Lindsay Halligan was the only person in the grand jury room, because it's only her signature, these documents, these indictments are invalid. But that's what the stakes are. That's what this is. Obviously these indictments are being thrown out before a jury gets to see them. And the reason for that procedure is because the legitimacy of these prosecutors is so important that it's mentioned in the Constitution under the Appointments Clause that principal officers must have the advice and consent of the Senate, or under certain circumstances, the approval of the judges of the district. And one more point, so far as the politics of this goes, there was, and we've had this conversation before, that one of the key citations that Comey and James brought in these arguments came from Samuel Alito when he was an Office of Legal Counsel attorney with the Department of Justice, that it was Samuel Alito who argued that you cannot have two interim U.S. attorneys in a row, which is exactly what happened in this case, where you had Eric Siebert, a conservative U.S. attorney with bipartisan approval, being pressured out because he would not bring this case. And therefore, they replaced him with a second interim attorney, Lindsay Halligan, first-time prosecutor. And that Samuel Alito says, and to give a kind of sense of where this might go from here because of the inevitable appeals, Samuel Alito says that's impermissible.
Yeah, I don't know what kind of flag Martha's going to throw up on her flagpole next to try to combat that particular ruling. No take backsies, but there are in the Supreme Court, as we know. Hello, Roe and Dobbs. But let's talk a little bit, just for a second, about the other. Let's focus on Comey here for a second. And I mean, Letitia James has other motions to dismiss as well for vindictive and selective prosecution. James Comey just filed one for grand jury misconduct. Does this moot those and stop them in their tracks, or is the door open to continue those because this judge dismissed without prejudice, which means that these cases can still be brought, although there's a bigger uphill climb for Comey because of the statute of limitations? But because that's still a possibility, can the courts, Judge Nachmanoff, in the Eastern District of Virginia, continue to resolve the other motions to dismiss either with or without prejudice? Is that door open now with this without prejudice dismissal from Judge Curry?
You know, I have never, in covering the courts for 2 decades, I've never seen a case where one viable and ultimately granted motion to dismiss raises a question of what to do with all those other potentially viable motions to dismiss. We'll see how the judges handle it. I think that right now there is no more US v. Comey. There is no more US v. James.
Right. It
Whether
might
I
be like if they bring charges anew, that to somehow make it past the appointments stuff, then we can reopen these looks into grand jury misconduct. Because I'm asking because I personally want to know
right?
what went
No,
on in the
it's a
grand
good
jury
question.
room. Because I was like, please just wait to dismiss a little bit longer, make this slow. I want to know if there was grand jury malfeasance. I want to know if Nachmanoff believes that there's vindictive and selective prosecution. I want to know if the Braunston literal truth defense, which was another motion to dismiss, is valid. But if this goes away, it would make sense to me, legally speaking, from my understanding, and I have a very limited understanding of the law, but unless you're facing that harm, then there's no need to go into it. So I assume that this will just be dead until and unless it's revived, and then we can continue on with those other motions.
I would expect that's correct. Right now, the case is dismissed. There's no reason for the federal judges to opine on what other potential grounds might have prevailed had James Comey and Letitia James had the ability to pursue them. As a matter of fact, early next month, Letitia James was supposed to go to court in Norfolk, Virginia, to argue her motion to dismiss for vindictive prosecution. And it's important to note, as you noted, that this is dismissal with without prejudice, but also important to note that in order to bring this case again, they will need to find a qualified prosecutor who is not unlawfully appointed, to bring it to pursue this case, knowing all that we know now. And they did not find a career prosecutor in the Eastern District of Virginia willing to pursue this case. They're going to need to find someone qualified for this. So that's something that I'm going to absolutely ask that I'm going to ask legal experts in this field, former federal prosecutors. Uh, can they, as they have done so far, bring a line prosecutor from out of district? We've had line prosecutors, assistant U.S. attorneys from the District of North Carolina, for example.
Right. That was my next question. Can an AUSA do this without a U.S. attorney on above them?
And in this particular case, these particular assistant U.S. attorneys were supervised by Lindsay Halligan, who was unlawfully appointed. So I don't think just the fact that it is dismissal without prejudice doesn't mean that this is a procedural hiccup, that it will be easy for the Department of Justice to come back and try to indict again. They will need to get a grand jury to indict. It's worth remembering that the grand jury in Comey's case indicted by a razor thin majority after being told by Lindsay Halligan that the burden of proof is somehow on James Comey, or that there is evidence that they could assume that there is more evidence, better evidence that can come out at trial. And even then, a razor thin majority of the grand jury voted to indict on 2 counts, rejecting the top count. And we could talk about any other alleged procedural irregularities from uh, evidence, the core of the case that was obtained potentially in violation of the Fourth Amendment, unreasonable search and seizure, that was obtained again in violation of the Sixth Amendment right to counsel because it may have been privileged information. That was the core of the case. So saying, okay, it was dismissed without prejudice because that's what Supreme Court precedent on appointments clause issues allows doesn't mean it's going to be easy to indict again. So this is a significant defeat for the Department of Justice in both of these cases. With prejudice would have had more finality. Either way, there was going to be an appeal fated. I think that's a safe assumption. But this is a resounding ruling in Comey and Letitia James's favor.
Yeah, and also, I mean, just you mentioned all those defects. There was never even a vote on the final indictment
Right.
for Jim Comey. What I in my justice dreams, I'm looking for because Nachmanoff's going to have to come in and say all this, cancel the calendar, vacate all this stuff, everything is moot or whatever. He's going to have to come in and do some sort of finalization. And I'm hoping he's like, but I would have dismiss this on vindictive and selective for this reason. I would have dismissed this because there's no operative charging document. I would have dismissed this because Lindsay Halligan got the Constitution wrong and persuaded the grand jury. I would have dismissed this because the FBI guy is a walking taint bomb. That's what I'm hoping, but I don't think that we'll necessarily see that. Judges have the authority to do those kinds of things. But I don't know that we'll necessarily see anything short of just, oh, everything's done. Bye. Just a real quick couple of 2 sentences from Judge Nachmanoff and the judge in the Letitia James case. So we'll see what ends up happening. We'll cover it. I know you're going to cover it on All Rise News. I guess my last question is that bringing another indictment against Letitia James is more likely than bringing another one against Jim Comey because of the statute of limitations. But again, I think you've already answered this question. Like you said, we have to find out from legal experts whether AUSAs can do this without a U.S. attorney there and what that would even end up looking like. I mean, I imagine you can still bring indictments when somebody's appointment is pending. right? As a U.S. attorney. So we'll see what ends up happening. I know there will be appeals. I'm sure they will try to re-indict using the grace period rule, which I think Judge Curry already kind of slammed the door on. But maybe some other sort of savings provision that I don't know about because I'm not a lawyer. But we'll cover it, and you'll cover it. And I thank you for taking the time today. We're going to run this interview on the Daily Beans tomorrow as well. And I hope everybody, if you get a chance, you subscribe to All Rise News. And if you have the means to financially support Adam's work, because he goes to the courthouses, he buys his own plane tickets, he gets his own hotel rooms because he doesn't have any corporate overlords paying for that type of stuff. So if you have the means, I know a lot of people don't right now, but if you do have the means to support independent media, I recommend that you do. Do you have any final thoughts on these two dismissals before we get out of here?
Only that, and thank you very much for that, Allison. Only that it would be very curious to learn whether there was ever an indictment against James Comey for the reasons that you said. The grand jury, the full grand jury, never saw what became the operative indictment. They saw what was essentially an edited version of the indictment that they were said to have voted on. That was a live issue before the court to have decided, but we will see whether any of that is resolved because the first one out the gate says case dismissed.
Yeah, and I'm just checking the docket one last time. Nope, all we still have is this. We don't have any more final statements from Judge Nachmanoff. But as soon as we do, you can bet that myself and All Rise News will bring them to you. Thank you so much, everybody, for jumping on and watching. I've written this up, and you can read the full ruling on my Substack at MullerSheWrote.com, and I know that Adam Klasfeld has as well at All Rise News. So we appreciate your time, and we'll probably see you again soon. Thank you so much. Bye,
Thank you.
everybody.
Bye bye.